All right. Well, thank you. Okay. Hi, everyone. My name is Rod Kite. I'm an attorney and the founder of Kite Law, a law firm focused on working with businesses in the cannabis industry. Welcome and thank you for attending today's webinar. This is a collaboration between Kite Law and the Hemp Beverage Alliance. Special thanks to our production partner, Peak Ventures. That was Caitlin, who you just saw. I'm joined today by rockstar attorneys Amber Loniger, an attorney with Kite Law and also the founder of Purple Circle, a boutique consulting service for cannabis companies who mean well and do good, and Michelle Bodian, a former partner at Vicente Law Firm and general counsel for the Hemp Beverage Alliance. So today's webinar, we decided to put it on as a way to help the hemp industry navigate the complex and seemingly ever-changing laws and regulations that impact us. It's really common for my clients, and I know that Amber and Michelle can also probably chime in and agree, for people to say, well, is my product compliant? And Amber, if you wouldn't mind popping up the slide about the business versus product compliance. Usually and understandably, when people say, hey, is this product compliant? They're wanting a simple, yes or no answer from us. But the problem is that there are a number of factors that impact this question. Things like, where do you plan on selling it? Is it allowed under state law? Is the product labeled properly? How is it marketed and distributed? Does it need to be registered? Does your company need to be registered or to have a permit? Are you complying with local ordinances? Are you age gating? Have you had it tested according to state requirements? And so on. So what may seem like a simple question can quickly devolve into a complex matrix, especially given that not only must the product be compliant, but many markets also require the distributor and or the manufacturer to be compliant. So we want to help simplify this process for you. Today, we'll discuss how you can stay compliant in all 50 states. And we're going to analyze this through the lens of the 3 pillars. Amber, I think you're still in control on that, if you wouldn't mind pulling up the 3 pillars slide. By the 3 pillars, I mean age gating, limiting access by minors, quality manufacturing, standardized quality control and testing and production and manufacturing of cannabinoid products, and clear and consistent labeling and marketing, uniform packaging and labeling requirements to provide sufficient information so that adults can make an informed decision about cannabinoid products they use. The overarching policy goal of the 3 pillars is to expand the cannabinoid industry such that adults can safely make informed decisions about what products they want to use. And of course, from a pragmatic standpoint, the goal for the hemp industry operator is to ensure that that operator and all of us are compliant in every state market in which we operate. So today we're going to go through each of the 3 pillars and discuss a number of practical and concrete issues and recommendations for you to consider. At the end of the webinar, we're going to take time to respond to questions. So feel free to type your questions in the comments just along as we go, and we'll be sure to circle back around and address them at the end. We anticipate that today's webinar will take about an hour, more or less, but we haven't timed it, and we also don't know how many questions we'll receive. And we're going to take the time to go through all the questions. So we appreciate you taking your time out to be with us today. Before jumping into our discussion, I need to make it clear that this webinar is intended to be educational. Nothing about this webinar creates an attorney-client relationship, and nothing that we say is intended to be legal advice. As you'll quickly learn, the determination of compliance for you and your products involves an analysis of your specific company, its products, and how and where they're manufactured, marketed, and distributed. So, of course, we're happy to consult with you individually, but today's webinar is not a legal consultation session. Rather, it's intended to raise awareness about the issues that need to be addressed in order to stay compliant. Finally, at the end, we will briefly discuss resources that we can make available to you, including a brand new licensing guide to help streamline the compliance process while also reducing the legal fees. So before we kick it off, any comments from you, Amber or Michelle?
No, just excited to be here. Thanks for including us.
Oh, we're super happy for you helping out here, Michelle. Well, let's get started then. So the first thing we're going to talk about is pillar 1, and that is limiting access by minors. And Amber is going to discuss the piece of that is your business compliant. So with that, I'll hand it off to you, Amber.
Yeah, thank you so much, Rod, and thank you to everyone for joining us here today. the three pillars are really important. And, while these requirements may not be in effect in certain markets that you're operating in, we do recommend, adhering to them as best practices and, really demonstrating that this industry can self-regulate and, operate responsibly and transparently with public safety at the top of mind. Um, so, of course, pillar one, limiting access by minors to hemp cannabinoid products. And I'll talk a little about that in the lens of business compliance. And really, what this means is, regulators want to vet businesses involved in this industry to ensure that they are operating compliantly and transparently. So, that could start with a hemp business license. And we've seen several states start to require these hemp licenses over the last couple of years. California has been doing it for a while, but you've got more recent states like Georgia and West Virginia that are coming online and requiring businesses to get licensed. And sometimes that even means you need a license to sell your products there, even if your business is not physically located in that state. So, remote sellers, e-com, wholesale distribution, whatever your business model is, we want to take a look at that business license and see if it's a requirement for you to apply. That is not always the easiest analysis. And to be frank, sometimes the law isn't super clear about whether an out-of-state company needs to apply for and obtain one of these licenses. So, that is an issue that, work with counsel to understand, talk with the regulators in that state to understand whether your business is operating compliantly in that regard. Along with that, a lot of times will come, registering your business with the Secretary of State and getting the appropriate tax licenses that you need. And again, this might be a little counterintuitive if your business isn't physically located in that state. But if you're selling or distributing products there, chances are the state wants you to pay taxes on that activity. And you'll need to register your business as what they call a foreign entity or an out-of-state entity. And each state has a process to do that. So, sometimes that's not super clear, but when you go to apply for the hemp license, it's clear that they want a letter of good standing from the state's tax division or whatever the case may be. And you kind of have to start working backwards almost. More common for businesses that are physically located in a state, of course, getting some of the zoning approvals, local business licenses, local tax receipts, whatever you may need for where your business is actually located is super important as well. And all of that, ties into, giving regulators visibility on who is operating in this space so that they can ensure that these products are safe and being sold to those who are 21 years of age or older. Even further in that regard, though, for limiting access by minors, having signage in stores indicating that folks need to be 21 or up to purchase these products and consume them. If you're online e-com sales, having your website age gate and even ID verification at checkout and signature and ID verification upon delivery. We're seeing different states take different approaches to this. But, as a best practice, we do recommend, ensuring that your products are only getting into the hands of those who are 21 years of age or older and really, exercising all of these practices that you can to make that guarantee. So that's just a little on the business compliance side. And then Michelle, I'll turn it over to you to talk a little bit about product compliance and what that means for age gating.
Sure, appreciate that. And kind of two different buckets with all things. It is what state law says you should do and what might be a best practice in those states that haven't quite caught up to the reality of the industry. So kind of broadly speaking, as Amber said, 21 plus would be what we'd recommend. Some states that's mandated. Other states are still have it at 18 plus. Some states don't quite have an age gate yet. But certainly best practice in order to minimize adverse health events would be to have the products be 21 plus. How does one do that? Amber touched on how you do it at the store level, but on the product level, put the words 21 plus on it somewhere. As simple as that. So that can come in a variety of formats. It can be, an octagon that says 21 plus. It can be an official symbol, such as the one presented. Right now, the state of Connecticut is the only state that has in regulation a required 21 plus symbol. So that is on the Department of Consumer Protection's website in Connecticut. It says 21 plus, it's red, it's in a circle. The plus is in an annoying upper right corner, whereas most people have it in the bottom left. So that is the only state right now that has a 21 plus mandated symbol. That is going to be changing soon. Minnesota would be the second state when they start enforcing, when they switch over their regulations. They will have, actually pretty much looks like this symbol with some different colors. So it will be this 21 plus, not for children, with the Poison Control Act number there. Take a look. If you're selling in Minnesota, though, they're fussy about their colors and the size of how it's going to be displayed. But absent sale in those two states, you still want to, in some form or fashion, include 21 plus. Typically, these are set off by some type of colors, bold, somehow indicating, those that have been designing labels in this space for a while, it can become kind of a C, and your warning statement block can get pretty lost. So you do want that 21 plus to stick out, whether it's red, yellow, black and white, somehow do make that emphasized. So that's the simplest way to convey 21 plus, either words or symbols. And then the second way, to make it difficult for minors to access. So even if you have the symbol on there, what's the additional steps you can take? You can add child-resistant packaging, tamper-evident materials to the product. Again, some states mandate this with different rules, whether you're a beverage or a gummy or a vape. But absent mandated requirement, it's just a good thing you should do. So having it a little bit of a barrier to entry. And I know they can be difficult to open. I struggle sometimes to open these, but they're there for a reason. And the idea is to limit, once it's in your home. I've got 2 small children. I watch them most of the time, I think, but you never know who's there, who can get access. So it's just a way to ensure someone with some skill can actually open up this product. And then I think Rod's going to touch on a little bit of the advertising and packaging, how you can kind of design your overall look and feel to not appeal to children.
Yeah, thanks, Michelle. The packaging, I think there's always been a question, obviously with gummies and things like that about the flour, and I always have trouble myself like getting into it. But I think consistency is really helpful. So yeah, I want to talk about the advertising and the labeling and marketing restrictions when it comes to the design of the product itself and the packaging. So states are increasingly enacting laws and regulations that prohibit products and packaging that are, quote, attractive to children. Now, typically this refers to products, gummies would be sort of the number one that we think about, that are brightly colored and may also be shaped like animals or fictional characters. But it can also refer to packages and labels that are brightly colored or also using colors. The biggest problem that we're seeing is that the standards are pretty subjective. In fact, wholly subjective. We've talked to regulators, and some regulators will actually take the products home, the labels, and show them to their kids, or they say, well, we have kids and we think this, or some of them, they're all using their own sort of internal measures. So what one regulator may deem to be appropriate packaging, another regulator may flag as a violation. And so for this reason, we usually recommend that products, again, usually gummies and similar food items, be in sort of plain shapes, squares, or not square, the cubes, or triangular shapes, things like that, rather than in the shape of something specific. And that for packaging, that you use more muted colors. And of course, this isn't also entirely subjective, but you might have a design or something that uses certain types of vibrant colors. But I think we can all sort of visualize what colors that might be attractive to children and colors that aren't, and we want to err on the side of them being a little more conservative on that front. But then also the big issue is that no animals or characters are used on the labels. Now, of course, this can be difficult when your brand's logo contains a character, and we've dealt with that issue. And unfortunately, in most cases in which a company's logo contains an animal or character, the best practice is either not to use the logo on the packaging, which can be difficult, or to change the brand's logo, which can also be painful, expensive, and difficult. But usually it's a good long-term investment, since we see this requirement just ramping up as more and more states adopt laws that prohibit packaging that's attractive to children. Now, as a quick side note, I just can't help but say, on a related note, don't manufacture or sell knockoff counterfeit products. You know, the D8 Skittles and Nerd Ropes, the D9 Cheetos, etc. In the media, most law enforcement and regulatory raids, if you can kind of picture articles that you've read and news stories, they'll contain pictures of all the products that were seized, and prominently displayed will be these counterfeit products. This makes the industry look really bad, and it's what the anti-hemp and broader anti-cannabis politicians use to push through bad laws. So, given that everyone here is literally taking the time out of their day to attend a compliance webinar, I doubt that any of y'all, are manufacturing or selling these products. But I think it's important to take a stand against them, as they really do literally threaten to take down the industry. But to get back on track with the labeling and compliance, moving to from labels and the products within them as being attractive to children, moving to print advertising, the same rules, generally speaking, apply to print advertising. The exception here might be when the print advertising will only be accessible by adults. So let's say you've got a dispensary, and you ID check for anyone who comes in, so you only have adults in the store. Well, then you've got posters or marketing materials. It's the attractive to children thing is not such an issue in that capacity. Online advertising is a little bit different, and I want to make a distinction between direct to consumer sites where products are actually sold, and then a separate direct or not direct consumer, but an online marketing campaign where products are not directly sold there. For the direct to consumer sites where the products are actually sold, I think it's imperative that you use robust age verification processes. Simply clicking the box that takes 3 milliseconds. Are you 21 or older? Yes, boom. That's just not going to cut it. And we're seeing an increase in regulators attempting to make purchases from direct to consumer sites to see if they're compliant. And just clicking through that yes, I'm 21 or older button is not going to be deemed to be compliant. And again, what we're seeing is there's a major push. These products are being made available to kids. Kids can purchase them, and a huge number of times, law enforcement actions, regulatory actions, are premised on minors getting access to these products. So there are services that can be used that are not onerous, but that really do provide that robust age verification. Now, moving over to the pure marketing campaign, where products are not being sold directly, we recommend just following the same rules that I've previously discussed about labeling. Not using bright colors, animals, and characters, while also noting somewhere prominently on the campaign that minors are prohibited from purchasing them, such as Michelle was talking about with the various logos or whatnot. And one more quick aside while I'm on it, we're noticing an uptick in clients who are doing promos that contain like giveaways. And I just want people to be aware that most states have sweepstakes laws that prohibit certain types of giveaways, usually due to the similarity with gambling or gambling component. So, again, as a quick aside, I just want to say, before you launch a giveaway promo campaign, make sure that only adults can participate, and then run it by a lawyer to ensure that you're not inadvertently, running over, through an illegal sweepstakes. And then finally, before moving on to the next pillar, I want to talk about events. These are the things where it might be that you or a coalition of companies put on a special event, or maybe you're participating in an event. Just know that licenses or permits are sometimes required. I would always say 21 and up. Make sure again that only adults are able to use and purchase the products. And typically, if you're doing it at your own space, you're going to need, or someone else's space, you're going to need landlord approval. The last thing you want is to be evicted or to have things shut down in the middle of a great event because you didn't get landlord approval. And then, sometimes events, are allowed, and sometimes they're not. It depends on the state. And in particular, free samples. It's nice sometimes to be able to offer samples, but just know that some states prohibit that. Some states allow it, but within certain boundaries. Okay, so that is pillar 1, limiting access by minors. We're going to move to pillar 2, standardized quality control and testing in the production and manufacturing of cannabinoid products. And Michelle's going to address whether your business is compliant or not, and Amber's going to talk about is your product compliant. So I'll pass the baton over to Michelle.
Thanks. I wish we had a hand raise so I can ask, like, how many of you think your business is compliant? I don't know how LinkedIn works, but I imagine you can't do that. But yeah, taking a step back, much like the first pillar, there's what's required and then what's best practice. Like all things, hemp industry is moving, fast and outpacing the regulatory framework as it gets established each year. So in order to be making these products, kind of big umbrella, is it a food item? Is it a dietary supplement? Is it something else? Kind of depends on how you position the product and how you label it. And each of those will depend on the requirements, both at the federal and state level. At the federal level, I think we understand FDA's position on these products, but absent, robust enforcement, most businesses are still choosing to comply with Federal Food, Drug, and Cosmetic Act. So if you are making and selling a food item, that would at its basic level require you to register the facility with FDA as a food facility. You might be thinking, wait a second, FDA says these adulterated food products. I listened to a webinar, now you're saying register this with FDA as a food facility. Not providing legal advice, contact your legal counsel. If Rod or Amber, your legal counsel, contact them to talk about this. But in general, I can say most businesses that are making a gummy or a beverage, which is considered a food product, are still registering with FDA as a food facility. I am aware of FDA coming and auditing many of these facilities that have hemp-derived CBD, CBG, THC put into their products. They get audited, and that's the end of the story. I have not heard of any enforcement beyond that. So there's quality control within that. So registering your facility at the federal and state level for manufacturing as a food facility or as a consumable hemp product facility. And then within that, there's a whole host of laws and best practices. Again, much like the Federal Food, Drug, and Cosmetic Act, OSHA still applies to you. That is a federal standard that is typically enforced at the state level. I know there was a lot of press on the marijuana side of a facility out of Massachusetts about a year ago, but consumer health and safety of your workers, OSHA still applies to you. Make sure you're familiar. Make sure you know, especially on the flower side, less so on the other form factors, but anything airborne, any toxics, any hazards, any environmental chemicals. There's a whole host of fun rules that you need to comply with to make sure your workers are safe. Then there's GMP requirements, so good manufacturing practices. There's usually a little C for current, so CGMP for current good manufacturing practices. And this is typically accomplished through third-party audits. So making sure your facility is keeping up with the latest and greatest. Again, making sure the quality of what's going into your product is safe. And this also can start, before you're even ready for the certifications. In certain states, you're not required to have these certifications until you trip a certain economic threshold. So if your business grows from small to medium, in some states under their food programs, that's when you would trip having to get GMP certified or something like that. Other states, it's required to even get your license on the hemp side. So like with all things, it varies depending where you are, but knowing those regulations are important. And then kind of even absent that, your own record keeping, your own quality control process, your own recall program. If a customer has an adverse event, do you know which batch, which lot? Can you trace it? Do you know how to recall it? Do you know when you need to report something like that to the FDA? When does something trip an adverse event reporting? When is it just a customer looking to score some free product? So knowing what that line, no one laughs. That was supposed to be funny. Thank you. Knowing the line between what is mandated reporting versus what is just a customer issue, and having all of these protocols in place before something goes wrong. Because take it from me, like having to call your lawyer and be like, hey, someone says something really bad happened. Now what do? It's a really hard time to create policies and procedures on the fly and go back and recreate something. So my plug, try to figure out what you have. If all of these words meant absolutely nothing to you and you're manufacturing or selling a product, take 15 minutes and Google, reach out to Rod or Amber, try to figure this out now, because at least most of this should have been familiar to you. Now that I've depressed everyone, Amber.
No, it's so important, Michelle, and the recall stuff especially. We'll talk more about that soon, but having a strong batching system and CGMPs tie into that with batch production records and master manufacturing protocols. So adhering to those GMPs can really help on the recall front as well. But when it comes to product compliance for Pillar 2, quality control and testing and manufacturing, we're seeing a lot of changes in this area. So just a couple of things to talk about. First, these per serving limits for cannabinoid content. Some folks are referring to that as potency or dosage. I was recently schooled on LinkedIn that we should call it per serving limits, but whatever you call it, various states are setting up various milligram caps for consumable hemp products. And you're seeing that range from 1 milligram per serving to 10 milligrams per serving. And the tricky part is sometimes they'll say it's 1 milligram of THC. Sometimes they'll say it's 1 milligram of total THC. Sometimes it's 1 milligram of all cannabinoids. So you really have to look at this closely and understand your products and understand what's permissible in that market. Especially when a state requires hemp licensure, which oftentimes includes product approval. You are going to run into roadblocks in markets where if you have a 10 milligram per serving product and they're only allowing 5 milligrams per serving, you're going to hit that roadblock. So that's one of the first things I always look at is those per serving limits, but then also the minor cannabinoid restrictions. So looking at cannabinoids or cannabinoids, whatever you prefer, and determining, are there prohibitions against synthetic cannabinoids in this market? Is this a market that is measuring total THC in hemp products versus just Delta 9? You also have states like Kentucky that have gone even further and defined a list of what they call intoxicating cannabinoids, which all require product registration. And then there are non-intoxicating cannabinoids, which do not require that registration. So, understanding that the cannabinoid content in your products and what a state allows is going to be really important as well. Some states have gone as far as to define what products are allowable in that market. You're seeing a lot of states get somewhat restrictive in that regard. Some states are prohibiting flower-based products. We thought we saw that in Georgia for a moment, and then the regulators sort of turned around and said, well, you can do pre-rolls, you just can't do whole flower. And, you're seeing all of these very interesting distinctions coming up, but really understanding what products are allowed by form in that market is going to be really important as well. Then we move on to full panel testing. This is becoming more and more of a common requirement. As Michelle said, we've got requirements and we've got best practices. If you are producing a consumable product that people are going to ingest or inhale, it's really a good idea to go ahead and get this full panel testing, which not only is going to test the cannabinoid potency in your product, but it's also going to test for pesticides and microbials and foreign matter and residual solvents and concentrate products. We're seeing some states require residual solvent testing even for flower products, which of course doesn't make a ton of sense. But you want to go ahead and get that testing if it's a requirement and just show them that you've done your due diligence there. And as this market continues to grow and these regulatory programs continue to mature, this is going to be more of a hot button issue with commonly prohibited ingredients. And you see a list of them here on the screen of ingredients that are more and more commonly being named as prohibited for consumable hemp products. And understanding, what products these prohibitions apply to. Often for an inhalable product, there are more ingredient prohibitions than for an ingestible product, which may or may not be counterintuitive. Some states are prohibiting certain additives now, including coloring agents and other things. So, we're seeing a lot of changes in that space. And it's going to be really, really important to understand, especially for, a product that you hope to launch coast to coast in a regard, in multiple markets, looking at all of these requirements and really coming up with the highest standard that is going to be compliant in each of those markets that you're in. So, important diligence to do there as well. We've got some, differences in testing when it comes to, products moving from state to state. And I recently spoke about this at CANRA with regulators, in that you've got some states that are adopting what I call the approved source model, where if a product it was manufactured in a state that regulates hemp products similar to food safety programs or in that program, that business in that state can be considered an approved source, and those products can be lawfully distributed in state B. But you're seeing a lot of other states, not a lot, but some, that are now starting to require testing in the state of sale or in the state of distribution. So they really want to ensure that all the products being sold in that state are safe. So they're requiring that testing at a lab that they've approved in their state. And we've even seen Tennessee go as far as to say they want to see the COA on that lab's website, which of course creates a lot of hurdles for people. So I think you're going to see this issue come to a head a bit in the next, hopefully several months, but maybe longer, of regulators sort of cohesively adopting either this approved source model, that's my hope, or the testing in the state of sale, which would present a lot of problems for folks. Right now, I don't know that there's any way to avoid what can sometimes be duplicative testing in situations like that, where in your home state, it's required to test before the product leaves that market, but in this destination state, it's required to test in that state as well. So you are seeing some duplicative testing requirements at times. Additionally, of course, COA is always a big one. Having that certificate of analysis available, it covers all of the required testing groups of analytes, pesticides, everything that the state wants to see is on there. Again, if you're in multiple markets, really elevating this to the highest standard, looking at those limits of detection, the allowable limits of various analytes, and understanding what's the lowest allowable limit for pesticide B in all of the states that my product is going to. And if it meets that lowest acceptable limit, then I'm good in all of the states where I'm distributing this product. In addition to the actual product testing, there's requirements for other information that the COA has to contain, including that batch number that we've talked about. And that batch number on the COA has to also match the batch number on the product label. And that's all to, effectuate a recall. If a consumer has an adverse health event, they can call the manufacturer and say, hey, this product I have, it says it's from batch number XXXY. I had an adverse health event. You can go through that recall process to understand if it mandates a public recall or any regulatory reporting, and then go from there. But these COAs are really important to protect the integrity of your product and your business. But for product compliance, it's definitely something that regulators are looking for right away. So that was a lot. There's obviously a lot here with product compliance on the QA QC side. We can definitely look at some questions from folks, but I want to make sure we also get to pillar 3, and we'll move forward to that right now. And here's where we'll talk even more about packaging and labeling requirements. Ron, I'll turn it over to you to talk about business compliance a little bit.
Sure. Thanks, Amber. And I think, what's so, I guess probably frustrating is the right word to me is when I hear over and over again about how, the hemp industry is unregulated. And of course, there are certain states and certain situations in which we don't have the regulations that we need. But here we are, we're going to be circling around an hour here before too long, talking about all the different regulations and best practices that are required. So again, we're not there yet as an industry, but what we're having rules and things that are being placed on us, and also advocating for good rules so that we can move forward. So anyway, I don't want to dwell on that, but moving to pillar three.
I gotta come off mute. Agree. So as someone who has to read all of these regulations like you all do, there's just about 50 states of regulation, maybe like 42 states. What I think people mean is perhaps a lack of robust enforcement of those regulations. But to be clear, they exist. They're long. Sometimes they're 40 pages long. Like there's a ton of regulations out there. They exist. It might just not be that the state is actively enforcing it or actively enforcing it publicly. But we have regulations. If we didn't have regulations, the three of us wouldn't have had jobs for the past 6 years. Like they exist. They're out there.
That's exactly right. Right. I think there could be a lack of enforcement. There could be a lack of education, and there could also just be propaganda against the hemp industries. But in any event, regulations and laws exist. And I think for those of us that are on the webinar and people that are watching this later, I think it's important when you talk to politicians and regulators and people in the media to let them know that the regulations do exist. Whether we all alike and agree with them, is a different question, but they do exist. So so thanks for that, Michelle. I feel that validation. Pillar three, uniform packaging and labeling requirements to provide sufficient information that adults can make an informed decision about the cannabinoid products they use. Is your business compliant? So let's talk first about labeling. We've gone back and forth about labeling. There's a complex framework with varying requirements across the country. So currently, about 30 states have specific labeling laws and requirements. And while there's a considerable amount of overlap, there's also a lot of differences, many of which are just irreconcilable, meaning that there's no such thing as a one-size-fits-all label. This is a very unique situation in the United States, since the FDA has very specific labeling regulations for foods and dietary supplements. But the FDA has not issued any specific rules for hemp products, and in that vacuum, states have filled this void. Let's talk about the pros and cons of uniform labels. We generally advocate for uniform labeling requirements. Unfortunately, that's unlikely to happen anytime soon, as it's going to require, a federal law and or the FDA or some other agency to step in and top down it, so to speak. So the downside of a lack of uniform labels is pretty, apparent. You're faced with the choice of either creating separate labels for each of the states in which your products are sold, or creating a label that's mostly compliant in most states, but which may not be fully compliant in many states. But there is an upside. The upside is that this creates an opportunity for small, nimble businesses to flourish. And I often say this in general about the hemp industry, that these types of obstacles, things that frustrate us every day, there's no one labeling requirement, but they're what enable small businesses to thrive. So, for example, a Fortune 500 multinational company is not able or willing to navigate all of these issues. Any single state market is going to be too small to make it worth the investment. And taking on a risk of using a mostly compliant, 50 state label is going to make that company a target. So while this is a major problem for the industry, remember that it keeps out the corporate conglomerates and creates a market in which small businesses can find a niche. This is very Main Street versus Wall Street. So to get back to some of the practical advice, I think the biggest practical advice we can make about labeling and that type of thing is avoiding health claims. I've been preaching this for a decade now. But as everyone on this call should know, the FDA has consistently stated that neither CBD nor THC can be added to food or marketed as a dietary supplement. And I noticed that my buddy Gary made a comment earlier about CGMP and FDA and all that. And I understand, and we'll address some of these questions shortly. But this issue about CBD and THC in food is a separate issue. But fortunately, the FDA has mostly not enforced this position, with some exceptions. However, the FDA has been pretty aggressive in enforcing the prohibition on making health and medical claims. So the simple, straightforward recommendation that we have is to avoid using medical or health terms. And that's pretty easy when you're talking about, diseases like Alzheimer's and cancer and things like that. But remember that this also precludes things like anxiety, pain, and even sleep. And so we all work with clients to try and navigate this and maybe come up with some acceptable euphemisms and some implications that don't say that. But the bottom line is that crossing the line can make you a target for the FDA and even some state regulators. So, market your products based on things other than health and medical claims. And so with that, I'm going to pass the baton over to Amber and Michelle about product compliance.
Yeah, and just one more note on business compliance in this regard, along with the hemp applications, definitely be mindful of the states that require label approval along with their business license or product registration process. And you can see an excerpt of the West Virginia application here on the screen where they want to see a copy of each product label that you're submitting for registration. So, in those markets, they are going to be oftentimes looking for explicit compliance with their state regulations. You are starting to see a little flexibility with like or similar language, like or similar symbols, allowing some information to be deliverable through QR code on the website. So we're getting a little bit of flexibility there, but every once in a while you might hit a juncture where there's a state regulator asking you why your FDA warning is worded slightly differently, which can be really frustrating. But we'll talk about that next, and we've got some examples of the FDA warnings here, which can be really frustrating. But talking about product compliance in the vein of packaging and labeling, of course, is just a lot of what we've been talking about here already. Understanding if you want to attempt to pursue a uniform label for multiple markets, accepting that little bit of elevated risk in that you're not 100% compliant with all of those various markets requirements, or if you want to spend the time and money on the front end to do a more state specific label, as Rod pointed out, that's easier for some than others. But either way, just circling back to that batch number, batch date, expiration date, there's quite a few requirements that are coming on board. And I know I saw a comment about the ingredients list too, and how deep that needs to go. And you're seeing some various requirements pop up in that regard across the country. So we'll talk about some resources in a minute that we have available to help clients navigate labeling requirements in various markets, or even a memo of best practices that we've put together, which attempts to create that really elevated standard that's as compliant as possible in most markets. But again, when you have these variously worded FDA warnings, we don't want that on there 17 times. We're going to do our best to marry all of this into one statement and have that one FDA statement on the label. Michelle, did you want to talk a little bit more about packaging and compliance there? Anything else to add?
You should make sure your packaging is compliant. No, yeah, it varies. Again, what's required, know your state, know what's recommended versus required. The new fun thing we're seeing on the beverage side are package limits. So 4-pack, 6-pack, 12-packs. A couple states have now tried to introduce language about transaction limits. So far, none have passed, but that's certainly something to keep an eye on come January. You're limited to 4-packs in certain markets, but you can buy 12 4-packs. And I think legislators are realizing without some type of transaction limit, the 4-pack limitation is meaningless. How many containers of gummies can you bundle together? So just being aware, besides the child resistant, tamper evident, that kind of thing that we talked about, being aware of how many of those could be sold together. And then a little bit of the marijuana industry is starting to bleed over on the hemp side. exit packaging. That is not something that's really been here on the hemp side. But last legislative cycle at the state level, we saw a number of bills that were looking to introduce opaque exit packaging. So for those not familiar, when you leave the store, they put it in like a shame bag so no one can see through and see what it is. A little bit of that was being proposed, so likely to come back again when most states are back in session in January. But again, the name of everything we keep talking about, know the state in which you're trying to sell, know what the rules are, and then know how the agency is interpreting them. You know, the three of us could pick up a state and disagree about what it says. Unfortunately, this stuff's not that clear. So if you have any questions, states are usually freakishly responsive. And you can reach out under an anonymous AOL account. You don't have to do it under your business account, but reach out. I mean, no one uses AOL, so it's obviously a fake email. So you can reach out and ask them, like, hey, I just want to double check, is this how you're interpreting this rule? To Amber's point about a batch number, you know, you might think you understand what's required, but if you're not sure, reach out to the state and they can certainly guide you through the process.
Yeah. And Michelle, I don't know if you have anything to add specifically for beverages and child resistant packaging. Child resistant packaging has come up as a requirement in a few states. And I know we've had some comments about, like, should this be a requirement for topicals and other non-consumable products? And, I think we've seen resistance to child resistant packaging on the marijuana side as well. It creates a ton of waste. Is this level of child resistance really necessary? So it's difficult for me to recommend child resistant packaging, but given it is a common requirement and being adopted more commonly as we move forward, have to advise clients about that. But on the beverage side, is a pop top good enough?
Depends what state you're in. I will say within child resistant, each state's doing a different thing because, again, why be consistent or make anything easy? Some states flex their definition of child resistant to the federal code, to the CFR. And then you've got Florida, who chose to go instead with the ASTM standard versus the CFR standard. So child resistant, even within that, is not all the same. And what are the requirements? Is it self-certifying? Is it a third-party certification? Florida in particular came out with some guidance that is sort of publicly available. They didn't post it on the website, but it is on official letterhead, was sent to all licensees. And Florida concluded pop tops are child resistant according to ASTM standard. Whether or not they're child resistant according to CFR standard, the federal standard, you'd have to determine kind of on a state-by-state basis. And then a number of states' legislature is exempting beverages from child resistant. So they want, and topicals, typically they would want a gummy container or another form factor to be child resistant. But we've seen beverages and topicals be exempt from those requirements in about 6 states at this point.
Yeah, and then don't even get me started if it's a multi-serving beverage. Like, there's a lot of questions here, and that's where, Rod mentioned at the top, the matrix. You can't just look at one aspect of a product and determine if it's compliant. There's a matrix that you need to go through to really determine if that product is truly compliant. But yeah, I mean, I think for the most part, that's it. Rod, do we want to look at some questions in the comments maybe?
Yeah, we do. Again, I want to thank you, Amber, and Michelle for really digging in here and providing the information you've provided. I want to thank the people that are attending. We do have some questions. I've been kind of taking account of them and copying and pasting them into a document, so I'm about to go over those. Really briefly, I want to just put a plug in, frankly, for some resources that we have to offer in an effort to consolidate and really to try to simplify the complex web of regulatory issues and requirements that we've been discussing, and also to save on legal bills. We currently have 4 resources, and I'll just briefly go over those. If you're interested, you can reach out to Amber or me directly. One is our 50-state hemp product spreadsheet. The spreadsheet contains a red light, green light analysis of different types of hemp products, the definition of hemp for each state, pending bills and legislation, and then notes regarding specific product restrictions. It tracks all 50 states and DC for several categories with pertinent statutes and regulatory provisions, comments, and links. It also includes real-time updates for a period of 1 year. We also have a hemp labeling state-by-state spreadsheet, and that's what I was talking about earlier. With there's about 30 states that have labeling specific statutes and regulations, and that includes a detailed spreadsheet, again, for a year, real-time updates. We have a hemp labeling guidance document, and this is more for that. Hey, I can't do 30 different labels. I want to have one label that really covers most of the bases. So this is a really sort of a legal memorandum of it's almost 15 pages, single spaced, but it provides detailed information, analysis, and specific recommendations for best practices in hemp labeling. And then finally, a brand new resource that we has not even, this is the first announcement of it actually, the Hemp Product Business Licensing 50 State Overview. This is a quick guide to hemp product and business licensing across the country. A lot of these things that we've been talking about today, are you licensed? Is your product licensed? What type of licenses or permits do you need? And that type of thing. So it's organized into 5 practical sections to help you identify exactly what type of licensing your business or your product needs and where to do it. It also includes a quick reference map. So again, these are resources, and our clients that use them typically get those. They can kind of do the analysis, and then have questions or need a follow up. And of course, they do that with us. So feel free to contact me or Amber directly about those. Michelle, I wanted to give you an opportunity if you have any plugs to make. The Hemp Beverage Alliance.
Yeah, join the Hemp Beverage Alliance. Very
Absolutely. Absolutely. The Hemp Beverage Alliance is doing amazing work, and you're doing great work. And I'll just put a plug in for Michelle and her LinkedIn account. She is on top of it. Michelle, you do a great job of just popping up. This just came out. This just came out. This case, this regular. So just following Michelle can be a huge resource in and of itself. So with that, I'm gonna jump into the questions, unless there's anything else before we go there. Y'all have anything else to say? Okay, great. I just kind of grabbed them off the comments as they were coming down. So they're not in any specific order except for chronological. So Mitchell said, can we all agree that topicals do not need child-resistant packaging? The mass scale use of child-resistant packaging has been an environmental nightmare. Yeah, it has been. And we just touched on this actually with topicals. I might say the only thing being if there are topicals that contain THC concentrations such that their use could actually be potentially detrimental to minors. I tend to agree. Any comment there, Amber or Michelle?
Yeah, I tend to agree with that. And I mean, I think you're going to continue to see, more and more breakouts and various products being treated somewhat differently as we move forward. I think more and more lawmakers and regulators are starting to realize like it's not a one size fits all approach. So hopefully we'll start to see more carve outs like that.
Yep. And I just noticed that Andrew said, do you know of any state that requires child-resistant packaging for firearms or ammo, exit bags for them? Of course, I'm not aware of any, and that's a great, that's a great point from a policy standpoint. Absolutely. Thanks for bringing that up. So Ali said, one thing I was hoping to touch on is the transport of hemp products and thoughts on future state licensing requirements for distributors of hemp products. I haven't looked specifically, but I don't think I've seen any specific licensing requirements yet for distributors of these products. Let's see. For distributors, yeah, thank you. I appreciate that.
Yeah, I mean, really, starting in 2019, some states have thought through each step of the supply chain and requiring distribution licenses. New York was one of the first states that has, it's called a wholesale, not a distributor license, but those licenses have exist for consumable hemp product. There was only about 6 states for about 6 states for about 2 years. And then with the emergence of the beverage category and a lot of alcohol wholesalers selling these products, this past legislative session, we did get 4 more states add on hemp product specific distributor licensing requirements. So they definitely exist. They're out there. And it sounds like Kite's compiling a list of all of these licenses. So maybe, shameless plug, buy their chart and it'll list which states have those. And some states even require it, like New York, even if you're not physically in the market, even if you don't physically have a warehouse in New York, if you're an out-of-state business selling to a licensed retailer, you pumpkin into being a distributor or wholesaler. So even as a brand, you might need to have that license. So lots of nuance there. And it sounds like there'll be a great resource available soon to kind of dive into that.
Yeah, thanks.
Yeah. And I would
So,
also add, so sorry, Rod, but,
no, jump in.
several states are defining manufacturing quite broadly, to include, packaging and even just storing products. So, definitely looking at that definition very closely, determine if you're conducting an activity that sort of implicates that is going to be really important. And then, on the wholesale side, I think there's a lot of sort of different interpretations about this, but Texas specifically, which is all of our favorites, spoke with a rep there recently, because there's some information on the CHP website that says a wholesale license may be required from a different agency. So I spoke with that agency, and the rep, was like, well, we're not really sure. If you're doing a medical device, you might need a medical device wholesale license, but if you're just doing consumable hemp products, you don't need this wholesale license. And so the guidance wasn't like super clear. And sometimes the regulators may not even know exactly what you need to do the business that you're doing. So, consulting with lawyers and having that really strong relationship with regulators is really important.
Yeah, I think regulators get a lot of flack, but we've all interacted, spoken at Canra events and with Canra regulators, and regulators by and large are acting in good faith, trying to do their best with these new emerging regulations and new product categories and methods of distribution. And so, they can be a good resource. Sometimes you might need to use that, AOL.com, email if you're kind of worried. But as Michelle said, but I agree. It's sometimes it's helpful to work with the regulators, but to talk it out with counsel. Moving on to another next question. Gary says CGMP designation is still possible, even though violating the FDA and C Act through adulteration. In other words, the FDA contends that, again, adding CBD or THC to food or marketed as a dietary supplement is illegal. It's an adulterant. And so, how do we get CGMP when that's the case? And my understanding, and certainly chime in, Michelle or Amber, if you disagree or agree, is that is possible, certainly at least in certain circumstances.
Yeah. It's interesting. In Florida, CGMP certification has been a requirement for marijuana companies for years. Like they have to get certified under GMPs. So I think even in that industry, which arguably is federally illegal in many senses still, you're seeing that level of enforcement. So, same with OSHA. I think a lot of people feel like, and Michelle said this earlier, OSHA doesn't apply, but you are seeing enforcement from these agencies and requirements related to those processes.
Yeah. Lisa says, thanks for your comment, by the way. The content's excellent. She says, reading through the comments regarding distributors, are we trying to follow a failing state model? The current state licensed market approach makes it impossible for small minority-owned businesses to survive, much less to thrive. We know this because we launched in California's dispensary system and pivoted to direct to consumer. Yeah, we feel it, Lisa, for sure. I think, the webinar is more sort of talking about, what's out there versus, an advocacy type platform. But B, I think, there is a distinction typically being made, where a distribution license or permit for a hemp company would, be, I think, pretty fundamentally different from a distributor license under, say, a state marijuana medical or recreational program, in terms of the costs, the application time and expense necessary to do that, and what it covers. I'd say that the issue here becomes kind of the thing we keep talking about state by state by state is, it might be pretty easy to get a distribution license in state A, but what if you're DTC and getting them in, 30 or 50 states, if it becomes that can begin to be onerous. So certainly I feel it, but I do think we're talking about two fundamentally different types of distribution licenses. Any other comments on that?
Yeah, I mean, I'll just echo that. These hemp license applications tend to be open and ongoing. They tend to be rather short, minimal disclosures. So if you come from a cannabis world, it's going to feel a lot different than the licensing system in that world. And, I think we're also seeing some elements of the alcohol distribution system coming in as well. So you're seeing different models being implemented in different ways. And I think, give it some time and hopefully we'll see a promising model shake out that, both protects public safety, but also offers opportunities to small businesses without, creating those barriers that we've seen in other industries.
Yeah, just as a little anecdote, I was talking with someone. This is a couple of years ago, but they were, kind of coming from the marijuana side, and they were asking about hemp licenses, and we were talking, and I don't remember the exact numbers, but I think I said something like, "Yeah, I mean, I think the cost for a license, in X state is about 100 or whatever." Blah blah, and they said 100, but that's not much different. And I was like, "Really?" And they thought I was saying meaning $100,000, and I went, "No, $100." And so I think in a lot of ways it's pretty different. Doesn't mean that it's perfect, of course, but different. Kayla, uh, you said, will you share these slides with attendees post session? Yeah, and just so everyone knows, we're gonna put this out so it'll be available, after the live session, so people in the future can watch this and look at the slides and whatnot. So thanks for asking. Michael says, curious on how companies under 21 CFR 101.4 need to be listing all ingredients for the emulsified ingredients, but brands don't seem to be doing that. That's a great question, Michael. And I'll take a stab, and then certainly happy for Amber and Michelle to step in. First of all, 101.4, the CFR, is a CFR that talks about how you need to label ingredients. And I won't read the whole thing, it's long, but it just essentially says ingredients are required to be declared on the label or labeling of a food, including foods that comply with standards of identity, blah, 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 shall be listed by their common or usual name and descending order of predominance by weight, and so on and so forth. And so I think generally speaking, the ingredients within the emulsification should probably be listed in most cases. And you say that brands aren't doing it, probably we're all moving to a place where they will be doing that. So I think that's my answer. Any follow up from either of you?
Oh yeah, that sounds great.
Okay. Moving on, we're getting close to the end here. Mitchell says, and this is a two-parter, when I wrote for a hemp company, their rules on health claims could best be summarized as you couldn't talk about specific medical conditions, but you could talk about general symptoms. So, for example, this could improve your sleep cycle versus this helps with insomnia. Is that a valid strategy to combat the health claims issue? Yes and no. I mean, this is something we deal with, and I can't tell you the number of times that I can say for me, and I know for Amber and probably for Michelle, we've had clients send their marketing or their labels, and it's this whole thing like, well, isn't this that? I think that it's really easy to get too close to the fire. Maybe is a way to say that. I think sometimes we can convince ourselves that we're not making medical claims when a regulator would absolutely say that we are. So again, the best practice is just to step back from that and be much more conservative, when addressing health and medical claims.
Yeah,
and then Mitchell also, yeah, please.
Sorry, I was just going to say, I'm pretty sure I saw something this morning about them sending a letter out about the use of the word calming. So you are even, I think they are starting to go even that little bit further, avoiding the word calming in your marketing.
Yeah, for sure. There's a difference and this is not the webinar to get into that, between sort of dietary supplement, structure function claims versus drug claims and all of that. Again, it's just the safest bet is just to steer clear of that to the extent that you can. And okay, moving down to Mitchell also says, can you even be eligible for FDA medical device testing? It seems like a catch-22. Amber, you were talking about medical devices. I don't know if that's something that you can respond to.
Yeah, I mean, I think I'd want to know more about the specific products, but when talking with Texas, medical device was a very specific item, like an inhaler that a person is going to use. So, I think it depends on the product itself, but based on what we've heard today, I think it's fair to assume that any FDA requirements, may be applicable to these products. So we just want to test everything out, be aware of them, consult with counsel, reach out to regulators anonymously, even if needed when there's a question.
And Deepesh and then Cole followed up with a question that I was absolutely expecting. It's not specifically applicable to this webinar, but I think it's timely and I think it's worth responding to. So thanks for asking. Any interest to elaborate on the passing of the Senate Appropriations Bill at the federal level? Curious if we all feel federal reform will occur or will hemp gear towards state MJ programs? So I'm happy to provide a quick response to that. So what we're talking about here is the fiscal year 2026 appropriations bill. It's how we fund the government. Both the House and the Senate, the committees that are sort of responsible for this, again, not to get too deep into the legislative weeds, have passed out of committee language that would, for the most part, kill the hemp industry, certainly the cannabinoid hemp industry that we're talking about here today. The Senate version does contain a 1-year sort of sunset provision. In other words, that these hemp killing provisions would not come into effect for a year. We don't know. The appropriations bill has not passed either the House or the Senate, and then once both the Senate and the House pass a version, then they have to be reconciled and then passed into law that way. So we're a little bit of ways down the road from it passing. But that being said, my personal view is that we're likely to see that language, that bad provision in the final version. And I think we're also likely to see that 1-year provision as well. So the key issue is, okay, so we're surviving another year, but the bigger picture is, will we survive past that? And so I think, this next year is going to be a very pivotal and important year for the industry, where we're going to do a lot of lobbying, a lot of outreach to people, our representatives in Congress, and frankly, as an industry, a lot of self-promotion about the very things we're talking about here today: safety, keeping products out of the hands of minors, consistency in labeling, and all of that. So I think that's what we're looking at. I tend to be, cautiously optimistic. We have a good industry. We have a lot of people that want these products, and we have a lot of really good players doing the right thing. So I feel cautiously optimistic, but we don't know what that's going to look like, this time next year. So I'm happy to open the floor to you, Amber and Michelle, to hear your thoughts.
Yeah, no, I mean, I would just say, these headlines are tough. We've got a lot coming at us on a daily basis. Take care of yourselves. Try not to ride the roller coaster too much, as Rod said. We're a ways out from this thing passing, and if this language is included, we'll have a year from that point on, even, to figure out next steps. So, it can be tough sometimes, but stay optimistic, stay cautious, stay in touch with your counsel.
Yeah, and because I keep just bringing us down, I guess I would just say, where there's fire, there's smoke. And obviously there's efforts afoot at a congressional level to walk back a lot of the market that we're participating in. So this is not the time to bury our head in the sand and assume someone else is going to take care of it. We all need to dig in and work together, whether that's through shameless plug of a trade org or individually through your business. But I do think Congress and elected officials need to hear from all of us. And if you don't personally, everyone listening right now, know who your elected official is, and if you haven't started the dialogue with them and let them know you're participating in the business, sounds like you should do that this afternoon. Shoot them an email and say, hi, I'm a hemp business. I'm concerned about what's happening federally. I would like to meet with you and discuss how a prohibitive language would impact myself, my business, and let's work together to find a regulatory framework that works for us all.
Absolutely. So I'm going to address what looks like the last question. So if anyone else has any questions, pop them up real quickly right now. Otherwise, we'll answer this question and wind up the webinar. Thank you again, everyone, for being here. Thank you again, Amber and Michelle. Katie says, I'm curious if anyone manufacturing acidified foods in the hemp space has run into issues when submitting the process to the FDA. I have not. In fact, I'm not aware of any submissions to the FDA about processes that that we've worked with. Amber and Michelle, if y'all have, then feel free to respond.
I'm not, so we should get another question so we can sound smart.
Right, exactly. Right. Okay, well, listen, I think that's going to wrap it up. Again, thank y'all for attending and for your time. And feel free to reach out to any of us individually with questions, or if you're interested in subscribing or purchasing one of the resources. Otherwise, have a wonderful day. Talk soon.
Thanks, everyone.
Thank you all.